want to welcome everyone back to the continuation of our podcast series. And we've been talking about the effect of the COVID-19 pandemic on the Ontario criminal court system and reviewing that in a series of podcasts. And today I'm here with my office manager, Jody Fulmer of Kruse Law Firm. Welcome back to our podcast today, Jody.
Hi, Mike. Glad to be here.
Today I'd like to chat with you, Jody, about the effect on in-custody criminal cases. And let me define in-custody criminal cases first of all. So in-custody means a person's been charged with a criminal offense, they've been brought to the county jail, and they're either A, waiting for a bail hearing, B, waiting to be released, hopefully on consent of the Crown, waiting for their trial, or they're sitting doing some dead time waiting to plead guilty. So that's an in-custody case as compared to someone who's out of custody who's received bail.
Okay, yes.
So we want to talk about the effect today, and I know you have some information to give, and fire away, Jody. I'm happy to talk to you about it.
So, Mike, what are some of the concerns? Obviously, here you are as an accused, and you are sitting in jail during a pandemic. So, from your knowledge and what's currently going on, what does an accused person in custody have the benefits of being in custody at this time during a pandemic? Are the Crown attorneys and judges and whatnot, are they're being a little more amenable to try to stop the overcrowding in the jails, which has always, even pre-COVID, been a problem. So many people, unfortunately, in custody and don't have someone to sign them out or whatever, so they end up just pleading guilty and doing their time and staying in custody. But now, even the people that have been arrested and in custody don't want to be in a jail cell. So what are there any better options for someone sitting in jail, say when they do have their bail hearing? Do you think that it's an option? A justice of the peace would grant them bail with, a quarter of the conditions that they would be released on, and maybe not even ask for a surety to have someone sign them out? And we'll deal with that question first, Mike, and then I'll have another one for you.
Oh, sure, absolutely. And, there's tremendous safety concerns going on across the province. First and foremost, since COVID started in March, we've got all these people, thousands and thousands of prisoners sitting in jail.
Overloaded, yeah.
And they're concerned psychologically. We had some outbreaks, and this caused the justice system to go, whoa, we need to deal with this situation. Mm-hmm. So what happened, there was a number of things that came out of this. And first of all, we realized we got to get this population down because we're going to have tremendous outbreaks. So what happens, number one, when an accused was under arrest and was brought into court, say several days later for the bail hearing, what was happening all during COVID and even now is that the Crown attorneys were more apt to potentially consent to their release. And I can say this, I think those people, we need to limit people languishing in custody on a good day, let alone COVID.
For sure.
That was an important consideration. And when the Crown thought a bail hearing was necessary, in other words, we have to let the justice of the peace make the decision, present some evidence, argue they're going to stay in jail. What was happening there is the justice of the peace recognized the same thing. So they were giving the COVID benefit to people who deserved it. These weren't like mass murderers and things like that. But
yeah.
Some people with property offenses, minor offenses, they can get out of custody.
Like a break and enter maybe? Or
we were successful, and the Ministry of the Ministry Attorney General, the Crown's Defense Council worked across the province to limit the numbers in jail, get them out on bail. So first and foremost, you're more apt to be granted bail. So that was one of the effects, and still continues to be one of the effects of COVID. There's several others as well.
So what about if you're in custody? So that's great news. That I just want to rewind. Great news that they're kind of not as stringent with the requirements for someone to be released from bail on bail. But what about if somebody has a trial? They they were denied bail, or they were given maybe bail and they needed a surety, and they just had no one in their life that could sign those documents to act as surety for them. So they therefore sit there and then have their trial, but because of COVID, the trials weren't getting scheduled quickly. And so now, they're entitled to a speedier trial rather than someone out of custody. Is that right?
Yes, that's true. We want to get in custody people their trial as quickly as possible. So that's an interesting question, because what was happening from March 15th right to July 6th, there was no trials going on. There was nothing. There was so these people who had trial dates, they was getting putting over. So some person charged with a serious offense who's presumed innocent, by the way, and might truly be in fact innocent, couldn't get their trial. So there was a lot of panic about those situations. Now, thankfully, trials resumed July 6th, so we're prioritizing trials for in-custody people. So that's another benefit that they're getting right now.
Right, because, of course, they know where they're sitting.
Yes.
In a cell, and they, whereas other people that are awaiting trial dates are out of custody. So, yes, that's great news that they're taking priority with regard to the people that are sitting in jail. And so that's a positive effect for those people, not positive being in jail, of course, but positive that they're directing their attention to the ones that are in jail and trying to get their, be it bail hearings, trials, or whatever have you, even guilty pleas, scheduled quicker than others.
Yes, and I feel badly for the prisoners. Like, some people have been in custody for 2 years in the summer. Their trial was scheduled from March till July. It never took place. It's been put over for another year. They might be innocent. They might be guilty. Who knows? But they're presumed to be innocent. Everyone's presumed to be innocent. But what's happened as well for a lot of people who are waiting for either to resolve their case, they're in jail, they deny bail, or their trial. Now, the lawyer had to assess it, because they said, okay, this is a triable issue. I got a 50% chance of winning. So the Crowns were looking at all those trial cases, and they say, look, can we offer what we would consider a reasonable deal? We're not going to give away the farm, but instead of asking for 5 years in jail, as an example, I can use any example of time, we're going to offer 3 years of jail. So so the risk was lessened for defense counsel. So we're moving a lot of cases, we're getting resolved. I'll call it a COVID benefit, because we want to get rid of this potential backlog of trial delay.
Absolutely.
If we don't do this, if the Administrative Attorney General and Crown Attorneys did not do this, there would have been cases thrown out left, right, and center 18 months from now.
So although COVID has been a travesty for everyone in 2020, and through every tough time, we always want to try to put a different spin on things and look at a positive perspective of bad situations. So this is COVID with our firm and law in general, and some of the outcomes. It's a good time to get a lawyer. Excuse me, I got a tickle in my throat. Good time to get a lawyer.
Yes, absolutely. There's no question. And just to have a recap, number one, people getting bail easier. No, those people should have been getting bail, I would argue, and the justice system recognizes this. They should have been getting bail before COVID. We were too apt to hold people in bail in Canada, in Ontario, and that's a good thing. There's no need to have people with property offenses sitting in jail, or who don't have significant past criminal records.
Or a prior criminal record.
Yeah, exactly. So someone charged with a first-time sexual assault, they're not a menace to society throughout their life, things like that. Obviously, first and second degree murderers, or people so they're breaching all the time, they're not going to get bail. But it's been a cultural mindset shift for the Crown attorneys and the judges and the justice peace say, look, why are we putting these people in bail waiting for a trial even on a good day? So that's been a good thing. So we're limiting the numbers, we're protecting the safety, we're getting deals that are fair. These are not, don't get me wrong, the Crown attorney's not sitting there saying, oh, you're charged with rape, sitting in jail, we're going to give you a kiss, 30 days in jail.
Yeah.
A serious rape case, if there was a choice between the Crown giving the person, the range for a date rape, by the way, is about 2 to 3 years. if person's in jail because they've got breaches. So, hey, why can't we resolve this at 2 years or 2.5 instead of 3? That's been going on. We've been able to successfully, and I tell you, all these players in the system have worked remarkably well. And a great shout out to the Ontario Criminal Lawyers Association, who worked volunteer hours to clear out the jails, to work at bail. It's been a wonderful effort. And I just can't believe how all these people have come together to do this.
You know what? Everyone's been coming together. There's many people. There's too many people to thank for us anyway. With the firm and running a firm, and trying to get many different things. And that's another topic we'll talk about later, is the people we need to thank and how it all came together and how all of the systems came into place for us during COVID, practicing law. So great information there, Mike, on the in custody accused.
But Jody, it's been stressful times for everyone in society. You can imagine someone sitting in custody, waiting a year or two for
and allowed no visitors.
Yes, and waiting for their trial, waiting to resolve it. And we've, the Ministry of the Attorney General, the Crown Attorneys, Defense Counsel have intelligently dealt with this situation and granted appropriate lenient deals, granted bail what's appropriate. And there's no, if the public thinks, oh, this is totally inappropriate, it's not. We've come to realize there needs to be a cultural shift, that maybe bail should be granted more easily on a good day. Maybe we should think about resolving cases appropriately.
Well, you know what, Mike? I think for years the Crown Attorney, I mean, if you got arrested and were put in jail, they just want to, like, the Crowns are like, you're just, criminal. We're not even going to basically look at your file. You're staying there until, we'll see what the justice of the peace says, but no, you're not getting bail. So they were doing that with everything. Like, oh, no. There's no reason you're getting out. No.
It was crazy, like thousands of people, double bunking, triple bunking, dirty, not safe. And the last mention on this topic is the things that the Crown Attorneys have come to grips with as well, with all cases, and especially in custody cases. They've had to assess that case and say, look, is there a reasonable prospect of conviction here? Because if there's not a reasonable prospect of conviction, I either have to offer a very lenient deal or withdraw the charge. Why should we set a trial date on a case that's going to take up 2 weeks where we know we're not going to get a conviction?
Right.
They've done a great job of coming to grips with that too. And I'll tell you, we've been very pleased, both Defense Counsel and the Crown's Office and the Ministry of Attorney General, with the way things are going. And a great shout out to all those people.
Yes, we're very thankful that we have a lot of great people working all these things out for us.
Per usual, it's been great chatting with you today, Jody.
You too. Thanks, Mike.
And I really look forward to continuing our discussions in future podcasts.
Awesome.
I really hope you enjoyed our podcast. We are absolutely committed to bringing you informative and interesting criminal and DUI content. If you're watching this on YouTube, I ask and encourage you to like this video and subscribe to our channel. If you happen to be an audio listener, please follow us and stay tuned for more great content. If you've been charged with a criminal offense or a DUI in Ontario, please call us or reach out to us online with the contact form found at kruselaw.ca.